All right, our second case on the docket this morning, and for the record, it's May 6th. Case 24-1670, West Volusia Hospital Authority versus Volusia County, Florida. Council, whenever you're ready.
Yes, good morning. I'm John Mullen on behalf of West Volusia Hospital Authority, or WVHA, and I will reserve 5 minutes for rebuttal. May it please the court. In this appeal, we respectfully submit that the trial court committed reversible error in erroneously interpreting the plain language of section 409.915, subsection 5 of the Florida statutes. Questions of statutory interpretation are reviewed de novo, and this case turns on the statutory construction of one key sentence in section 409.915. It is that statute, and only that statute, that the County of Volusia relies on to impose an onerous Medicaid match assessment on WVHA, amounting to more than $3 million each year. The statute at issue provides, quote, in any county in which a special taxing district or authority is located which benefits from the Medicaid program, the Board of County Commissioners may divide the county's financial responsibility for this purpose proportionally, and each such district or authority must furnish its share to the Board of County Commissioners. Now those words, each such district or authority, are limiting. If every taxing district or authority was subject to this statute, there would not be a reference to, quote, each such district or authority, unquote.
Counsel?
Yes.
The word benefits in that sentence, it's a verb, right? It's the verb benefits. It's not the noun benefits like an insurance company pays out, correct?
Yes.
So it seems as though ultimately your argument might be that benefits from means receives benefits from. It seems maybe the plain language might go in the other direction. Can you address that?
Yes. We submit that the plain reading of the statute is in our direction, and that the county's argument here is not faithful to the statute. And it's also based on a flawed assumption. I'll explain both of those points. It's not faithful to the statute, I say, because nowhere in section 409.915 is there any reference to residents who qualify for and benefit from the Medicaid program. Instead, the reference is to the entity, to a district or authority which benefits from the Medicaid program. And also, nowhere in the statute is there any reference to potential cost savings that a district or authority might experience.
Wouldn't that distinction sort of swallow the entire rule? If you have a nonprofit hospital and all of the folks in the community are benefiting from what the nonprofit hospital does, arguably that hospital doesn't benefit from Medicaid because all of those benefits are being passed on through to all of the residents of the community.
I think that example, Your Honor, makes our point. If the hospital is receiving Medicaid benefits, it is clearly benefiting from the Medicaid program. And it's undisputed here that West Volusia Hospital Authority operates no hospital, does not receive a single payment from the Medicaid program. Unlike other hospitals.
If it's clear that they're benefiting from it, even though all of those benefits are being passed on to the residents, how are you not benefiting from it when all of your benefits are being passed on through to court?
And this sort of strikes a chord with one of the county's argument here, which is what I say is based on a flawed assumption. The flawed assumption that was adopted by the trial court here is that it assumes that WVHA would necessarily be the payor of health care services obtained by a resident if Medicaid did not pay for those services. And that is not necessarily true. And in fact, it's contrary to the broad discretion given WVHA in its Enabling Act, which we cite, quote from in the briefing. WVHA decides how it defines which residents are indigent and eligible for its services, and how it decides to provide access to health care for indigent residents. That's contained in the Enabling Act. There's no definition of indigency anywhere in the statute, and WVHA has that authority. So the question here is, the question for the statute is whether WVHA is an authority which benefits from the Medicaid program, not whether residents benefit from the Medicaid program.
Taking your argument a bit to the ridiculous end there, but it sounds to me like you're saying that the statute enables you to tax the people of Volusia, and then with unbridled discretion decide who you're going to and not going to give it to.
The Enabling Act says that obviously WVHA has to provide services, has to provide for the medical needs of people within the district who are defined as indigent. And WVHA has the discretion to decide what is the level of indigency and how those health services are provided.
So is it your
That's exactly
argument
what it does.
Is it your argument that your client could essentially cut out every person who is Medicaid eligible?
I think that would sort of take an argument to the extreme.
Well, I mean, yes or no, and then provide an explanation perhaps, but yes or no?
Yeah, but the answer is, again, the county's argument is based on this flawed assumption that WVHA would necessarily pick
Let's
up
take
the
the word
tab.
necessarily on. Don't fight my hypo, come on. I really need you to answer this question. Yes or no, and then provide whatever explanation you'd like.
Well, clearly there can be some overlap. Obviously, some people may be on Medicaid. If they're not on Medicaid,
Your client
they may
couldn't
qualify.
eliminate, your client could not eliminate the overlap, right?
It would probably not be eliminated entirely.
Right. Okay, that's what I wanted to know. But I understand what you're saying is that you don't your client wouldn't necessarily have to take the entire Medicaid role.
Absolutely.
Okay. Hey, I have a question. On the statutory interpretation side of things, and I understand that argument that you just made to be sort of more of a, even if we took the broader definition of benefit, right? You're saying, hey, maybe there's not so much benefit, but on the argument that we have to use the statute's definition, by the way, I do find somewhat persuasive the noun verb distinction. I understand how you dealt with that in your reply. I'd like to hear more about that, but before we get there, do you agree that Chapter 409 that seems to use the word benefit in certain places that clearly is different than the statutory definition? And I'll help you out. 409-1464, some fathers have greater challenges than others and would benefit from greater support. The chapter doesn't always seem to use the word benefit in the way that it's defined right at the beginning of the chapter. So do you agree with that?
Well, and the example you cite is a good one in that is clearly a different use of the word benefit than either what WVHA or the county is talking about here, frankly. That's a different use of the word benefit, and it's different than how benefit is defined in the
And I'm not asking you to give up your case here, but can we at least agree that sometimes Chapter 409 uses the word benefit in a way that clearly the definition of benefit in the chapter does not apply to you? Can we agree to that?
Well, that's correct, Your Honor. But here, of course, where the county goes and where the trial court accepted their argument goes too far, because it is divorced from the definition of benefit that is provided in the statute. Yes,
But so is the one I just read to you.
Yes, but of course, the example you gave me refers to is a different, very different usage of the word benefit, talking about benefit to a father. It's a sort of a psychological benefit.
A very general, yeah.
Yeah, it would be very different in the definition of benefit and another dictionary usage that you're referring to there, which is contained in some parts of the statute. But here, of course, what we're talking about and what we focus on here, the term benefit is defined in the statute as, quote, any benefit, assistance, aid, obligation, promise, debt, liability, or the like related to any covered injury, illness, or necessary medical care, goods, or services, unquote. That's the definition of benefit in the statute. And we said that refers to, obviously, a financial consideration, a financial quantity is used, is contained, is inherent in that definition. And
So it's more specific, a financial benefit, essentially.
that's correct.
What about 2561? Any payment of temporary cash assistance made to, comma, or for the benefit of, comma, any dependent child creates an obligation, et cetera, et cetera. That use of the term benefit seems to have a financial aspect, but doesn't seem to fit with this statute's definition.
Well, and I think that's one of the examples the county referred to in page 31 of its answer brief. There are other uses of the word benefit. But here our point was 3 of the 4 references that they cite, including the one that you just referred to there, do refer to benefits as a payment or a financial quantity. So we would submit those uses of the word benefit support WVHA's position on this issue.
Well, does 2561, yes, it does have a financial aspect, but is that talking about a cover in illness? Is it? I mean, maybe it is.
I think it is, Your Honor.
Okay.
When there's a reference to payment, again, this goes back right to the statutory definition of the word benefit, which is where the rubber meets the road in this case, of course. Benefit is defined as that financial quantity related to any covered injury, illness, or necessary medical care. And that's exactly how you have to read 409.915 here. The definition of Medicaid program, that's also provided in the statute, backs us up on this point. Because that definition of Medicaid program refers to, quote, the program authorized under Title 19 of the Federal Social Security Act, which provides for payments for medical items or services or both, unquote. That's in the definition of Medicaid program. That term is also used in the statute at issue here that you're required to interpret, of course. That definition bolsters our argument. And as this court, the 5th DCA, held in the Romero versus Fields Motor Cars case, quote, in interpreting the statute, we follow the supremacy of text principle. Namely, the principle that the words of a governing text are of paramount concern, and what they convey in their context is what the text means, unquote. That's the principle we're citing to here. And it is undisputed that WVHA, the entity, receives no payments from the Medicaid program. By contrast, many other taxing districts or authorities do receive payments from the Medicaid program because they operate hospitals and medical facilities. Those such taxing districts are properly subject to the statute because the statute allows the county to divide the county's financial responsibility among such taxing districts or authorities, which benefit from the Medicaid program. WVHA is not in the same position because it does not similarly benefit from the Medicaid program.
Because it doesn't have essentially a hospital or medical provider, right, that does this. But so one other thing, as I was reviewing the chapter for the context, and I don't know that this is dispositive. Maybe it's an important point, but maybe it's not. I wanted to, but it's kind of stuck out to me, so I thought I'd get your thoughts on it. Is the statute seems to talk about, when it's talking about payments to medical providers, it uses the word reimbursement. It doesn't use the word benefit, right? So I guess I just wonder, is that significant? The fact that your client doesn't have a medical provider that takes Medicaid cases, doesn't the part of the statute we're talking about doesn't reference a reimbursement, and so help me with that.
Well, I think the references in the statute to reimbursement, Your Honor, to double down on WVHA's point, there's a reference to, again, payment related to any covered injury, et cetera, goods, care, and services. That's the emphasis generally when it comes to the subject of what does benefit mean, how is benefit applied. I think the references to reimbursement are in the same vein.
Now, why doesn't if your client could not completely cut out Medicaid patients, then why doesn't your client meet the very definition you say causes your client to prevail, right? So your argument is, hey, we have to use the definition of benefit. But why doesn't your client fit in the definition? It's a pretty broad definition. It's not any payment. It's any benefit, assistance, aid, et cetera, related to. Related to is a very, very broad phrase, right? Related to a covered injury or illness. Why isn't the fact that your client, who can't cut out every single Medicaid patient, is able to take those Medicaid patients that it couldn't cut out and say, hey, we don't have to care for you, go elsewhere? Why is that not a benefit? Why is that not assistance? Why is that not aid?
Well, in context here, let's look at how related to any is used in the statute. As you said, related to, we know, is classic lawyer language that can be very broad. But here it's actually used in the statute's definition of benefit in a limited way. The way that sentence reads, it begins very broadly. Any benefit, assistance, aid, obligation, etc., related to any. Now, you see the narrowing in. Related to any covered injury, illness, or necessary medical care, goods, or services. Again, we start with a broad definition of benefit, but then we narrow it to something that's related to any. That's the emphasis on this financial quantity, the financial component of this aspect. That's what we point to as saying, that's what we're talking about when we use the word, when the word benefit is used in the statute here. It's referring to that economic or financial quantity here. And that's what the county wants to read out of the statute and ignore in the statute, instead relying on dictionary definitions, which are broader than what the statutory definition is. See that I'm just under 5 minutes. I'll reserve my remaining time for both. Thank you. Thank you, Council.
Police Court, good morning. Kevin Bledsoe on behalf of the County of Volusia. The county provided the trial court with overwhelming summary judgment evidence that West Volusia Hospital Authority benefits from the Medicaid program. We did that in the form of affidavits and exhibits. Part of those benefits included financially benefiting from the Medicaid program. Also, that Medicaid benefits West Volusia Hospital Authority by helping it fulfill its public purpose. Its public purpose to provide access to health care for its indigent residents. And the evidence was that nearly half of the county's Medicaid enrollees actually reside in the West Volusia Hospital Authority.
For the sake of hypothetical, this is far different than the affidavits and all the evidence that you provided.
Sure.
But for the sake of hypothetical, you have a special district for a library. And that library benefits from having healthier people within your community. It seems to me that's going to be too far broad reading of the word benefits in the way that we're using it. Where do you draw the line?
I think what makes our case much stronger is that the public purpose of the West Volusia Hospital Authority is to provide indigent health care, access to indigent health care. So maybe it would be a harder argument.
That's the answer to the question of they're way over the line, but I kind of want to know where the line is.
Well, I don't know, but I can say that I would think that if it was a mosquito district or a port authority, that would be a harder argument to make, and maybe that would be where the line is. I think the fact that in this case, the West Volusia Hospital Authority has a public purpose and a requirement to provide access to indigent health care is what makes this case the stronger case. I guess that's the best answer I could give.
The fact that they actually choose their patients based upon whether they're receiving Medicaid. Is that correct?
Correct, and that they fund, in this case the evidence was the Legal Services Department to help people get Medicaid so that they can save money, so they can get that benefit of financial savings, to not only offload its neediest, most expensive cardholders, but it also helps to prevent
that would seem to be evidence that at least they think they have an incentive to move folks into Medicaid.
I think it was undisputed that they benefit from the Medicaid program, and not just financially, but certainly financially, that they benefit from the Medicaid program, and actually quantified in specific dollars how we benefit from the Medicaid program, and that we actually spend money to help get our people on Medicaid and to keep them from coming to us so that they are on Medicaid. So I think that's
in the definition. I'm not a Medicaid expert, so maybe you can help me with this. This list of things here in the definition: benefit, assistance, aid, obligation. I think I got my head around those. When is there a promise, debt, or liability related to any covered injury or illness?
I think the best explanation, and I think my argument would be that because that is benefit defining as a noun, that it doesn't apply to benefits from, uses a verb in the 409-9155. However, I would say that yes, it is the noun benefit, meaning I don't know that that definition applies, but I also don't think it helps their case at all. Because
I'm
it's very
asking, who
broad.
would have a debt related to related to a covered illness?
I would say that the Medicaid benefits are the Medicaid benefit is something that the low-income Americans receive from the Medicaid program. So the low-income Americans receive the benefit, the aid, and the assistance when the Medicaid program takes on their debt, their obligation, or liability. So, I do think it's distinct from Medicaid reimbursement that the healthcare provider gets, which is a completely different statute. And of all those words, it's not
It just
included.
seems odd to call a debt a benefit, right? I mean, that's not sort of how we normally think of a debt.
Right. I would say the best way I could explain it is that the program is assuming the debt of the beneficient.
Okay.
Right. That would be my best explanation for it. I don't think that the Medicaid benefits, is what the provider gets. I don't think we think of our neurologist, let's say, as being on Medicaid benefits. They might get Medicaid reimbursement, but I don't think that in that sense that's what is there. And I do think that our definition, again, whether you use the definition benefit or not, I don't think it actually helps their case. But I think that the plain and ordinary meaning of benefits from as a verb in 409-915 Section 5 is helped by, benefits from, that they get a assistance from. It makes their mission easier. It actually also saves them quantifiable amounts of cash. So I think that the evidence, and evidence, by the way, that was undisputed. I mean, we put forth evidence that they benefited from the Medicaid program. They didn't put forth anything that countered any of the affidavits that we provided in the summary judgment, and they didn't provide any evidence of their own that they didn't benefit from the Medicaid program. So I think that the court's ruling was absolutely correct. Again, West Volusia Hospital Authority, they benefit from the Medicaid program when the program pays for its indigent residents to get health care.
Your opposing counsel made what I thought was at least an interesting argument in the reply brief to the noun-verb distinction. And I think it sort of went like this, that, hey, whenever you take a noun, and I think the reply brief used, and I've never really heard this concept before, but you verbify the noun. And when I read that, I was like, oh, okay, well, I mean, that does happen. Certain, we take nouns, words that are solely nouns, and we sometimes in society use them as a verb, right? I mean, we could probably think of examples of that. But you didn't have a chance to respond to that, so go ahead.
I guess, let's say, we say, let's Uber to the courthouse. Uber being a verb. That's a kind of a made-up verb that is kind of beholden to an Uber, a noun. Maybe that might be an example of a verbified, a verb that is beholden to a particular definition of the noun.
Yeah.
But if I said, my kids benefit from good teachers, that doesn't mean that the teachers are giving them cash. So I don't think that benefits from is, beholden to the noun that they're claiming it's beholden to, which is the receipt of cash reimbursements.
So in that formulation of the noun-verb distinction, the word verb as a benefit, going back to my original question, just doesn't have a limiting factor. And to your point, it's hard to draw that line. Is the line that your opposing counsel seems to draw, well then draw it back to the statutory definition of the noun benefit, seem to be at least a good nexus of what the limiting factor should be.
I don't believe so, because I think what they're arguing is really a narrow having mistaken an unnatural definition of what they think benefit is. And again, what they're saying the benefit is none of the words that the actual noun definition in the statute give. They want the definition of benefit to be Medicaid reimbursement. Again, there's a statute of talking about Medicaid reimbursement. Again, that seems to be separate. That's the one word that isn't in the list of many that the noun definition provides. So I think when we think about supremacy of text, and we're all textualists now. We're supposed to be looking at the definitions in the plain and natural explanation of what one would think with benefits from, and I think that's what the trial court correctly used, and that was consistent with the only affidavits on the subject. They benefit from the Medicaid program. To the extent that you want to say, well, it has to be financial, you got that too. To the extent that you have to say, well, they don't need to benefit from the Medicaid program because the Medicaid program is paying for health care, yes. West Volusia Hospital benefits from the Medicaid program. The program pays for its indigent residents to get health care.
So going back to the noun verb distinction, in this concept of verbifying a noun, do you think that, let's assume for a moment that there is such a thing as verbifying a noun. I think, you sort of maybe identified one who, well, let's Uber, right, over, and Uber, we traditionally would think of Uber, I think, as a noun, right? It's a name of a company. Do you see a difference? Do you think all nouns are equally verbifiable? or do you think that each noun maybe is different? Have you thought about that?
A little bit.
I'm going to ask your opposing counsel the same question.
Yeah, I think there are verbs that are, only words because they were, aside from nouns, solidify, liquefy, that are going to maybe beholden to nouns. But I don't know that all verbs were born from nouns. I mean,
are some words pretty much only nouns? Or at least heavily, primarily nouns.
Right.
And so if you use one of those words as a verb, I mean, that would be if verbifying is a thing, that would be a classic example of it, right?
Right. I don't think like, let's podium.
Yeah. Yeah. So thinking about the word benefit, is that traditionally thinking the average person, the average reader, right? Would they view the word benefit as only a noun? Or would they say, well, it depends on the context. It could be a noun, could be a verb.
I think benefit would probably fall in the category, it could be a noun or it could be a verb.
Right. Right. Like you wouldn't know, like if I just said, is benefit a noun or a verb? You would say, well, I need some context to know, right?
That's true.
But if I said, is Uber a noun or a verb, what would you say?
I probably would have said noun.
Yeah. Okay.
How about opinion? The word opinion. We write opinions, or we might have opinions. We're going to move from the supremacy of text discussions of opinions to verbifying.
Right.
A new buzzword for the year.
I would say that if you type in, or at least a few weeks ago, if you type in the word verbify into the Westlaw, the only hit you're going to get is the briefs of Mr. Mullins.
We're all going to be able to cite back to this case when we start seeing all Judge Eichenachel's opinions talk about verbifying over the next year.
Obviously, I thought it was an interesting argument.
I think it is interesting.
I had never heard the concept before, but I think it's an interesting argument.
I never heard of it either. It is interesting. It's an interesting verb. I guess it's a verb, right? Person noun.
I think if there's any other questions, I'd be happy to ask them. But otherwise, I think, again, the evidence was clear that they do benefit from the Medicaid program. I think the evidence was controversial.
All right. Thank you, Counsel.
In 1 minute, I'm going to address the subject of verbifying an act. But first, I can't wait to address the subject that the county has doubled down again on their reliance on the affidavits that they submitted to the trial court. And we submit that that is reversible error in itself. The county submitted those affidavits to try to suggest how the trial court should interpret the statutory language of Section 409.915. But it was inappropriate for the trial court to rely on those affidavits. It's well settled under Florida law that statutory interpretation is a matter of law to be determined by the trial court.
But counsel, it's a de novo review, right? I mean, if the trial court got the interpretation correct, it kind of, I mean, for our purposes, it doesn't matter. If the trial court got there the wrong way, the Tipsy-Coachman doctrine says it's an affirmance, right?
Under Tipsy-Coachman, I can't disagree with you, Judge.
So if we agree with the ultimate interpretation of the statute, it doesn't matter if the trial court sort of got there the wrong.
That's right, Your Honor. But I do think it's important the judge heavily relied on those affidavits to apply her rule or her decision, which was, well, that means that the WVHA benefits, because here I'm relying on these affidavits and they are going to put forth.
Providing a memorandum of law?
I'm sorry?
Is that any different than just providing a memorandum of law?
I think it is because the judge thought I'm relying on these factual issues that the county has inserted here through those affidavits, when our argument all along has been this isn't a factual question. Or if there's a factual question, there's only one, and that is whether or not WVHA receives benefits from the Medicaid
In
program.
the affidavits talk about how they, I get the term benefit is a legal issue, talking about in the context of the statutory interpretation, but the affidavits did say this is a financial benefit that your entity or your district receives. Now, that's factual information that a judge needs to rely on, because there's no affidavits and who knows if you have any benefits. They're saying, here's these benefits you got. I don't know that the affidavits then said it, therefore, in our opinion, it comes within the statute. I mean, that's the distinction.
Understood, Judge Lambert. And what the county was trying to do is, hey, we've got these dictionary definitions of the word benefit and what benefits means, and here's some affidavits to support these dictionary definitions that we rely on. Our point is that's going beyond the statute and the plain language of the statute. That's as far as the court should have gone. It didn't need to get into those factual issues. On the verbification issue, just the examples I like to use on for that is cited in our brief is you milk a cow for milk, you mine ore from a mine, and you benefit from receiving benefits. That's a use of where the noun and the verb are used together, how you can verbify a noun. In this context, our point is that WVHA does not benefit from receiving benefits, and that's where the verbification comes into play with respect to how.
That's one way they can get benefits. Can't they get benefit other ways other than direct reimbursement? And that's their point, isn't it?
That is their point, Judge Lambert. Our point is you have to look at the statutory definition here. Again, if we were talking a case where, like in the Romero case, there was no definition of rent in the statute, no definition of lease in the statute, so the court properly went to the dictionary. In this case, that's what the county wants to do.
I understood your argument, though, on the verbifying, to be that, hey, look, if you're verbifying a noun, that doesn't give you license to just choose from any of the definitions available in the dictionary. You are cabined by, this is how I understood your argument, you are cabined by the definition of a noun.
That's correct. Exactly.
Okay.
If the noun is verbified, it's important not to disregard the meaning of the word noun. And that is illustrated by Romero.
Remind me, is that your conclusion, or did you cite some authority for that we're cabined by the noun definition if it is indeed a verbification? I just don't remember.
Yeah, I think it's either explicit or implicit in the Romero decision. Romero doesn't use the phrase verbify, but that's what the court looked at when looking at the word rent. Since there was no definition, it talked about the noun use of rent, the verb use of rent, and how those interplay. That's the illustration.
And Romero, did the chapter use the same term in ways that clearly weren't consistent with the definition?
That's correct.
Okay.
And the example we use in the brief is simply, there's a third definition of the word rent. You rent a garment. You have to look at it in context. And that's why we say this court needs to look at how benefit is used in context in this statute. Again, bottom line is the county's imposition of this Medicaid match funding on WVHA is contrary to the plain reading of the statute. And we respectfully request that the court reverse the final declaratory judgment and remand for interim judgment in favor of WVHA.
Thank you, Council. Gentlemen, thank you. All right, I got indicated we're going to take 5. We're going to have a panel change. So we'll stand adjourned for, come back at about 10:25. Zoom just hears.